did not operate as a bar to the prosecution of the accused. Your Lordship, in the termination of this, we claim the indulgence of the court that records be made to the letter of the law, the spirit of the law, and the public policy in the consideration of this issue. Your Lordship, the law is clear and settled as the provision of section 36 of 8 and 36 of 12, which is to the effect that nobody shall be convicted or held to be guilty of an act which at the time of its commission did not amount to a criminal offence. And also nobody, Your Lordship, can be held to be guilty of a crime that is unknown to law, except or otherwise stated, written down, defined in a written law, and the penalty prescribed. Your Lordship, this is the letter of the law, which is clear and unambiguous. Therefore, we never bring to the notice of this court that the position of the Court of Appeal that Section 6 of the Criminal Code Act is Section 6 of the Criminal Code Act is
Criminal Code.
Okay, sorry. That Section 6 of the Criminal Code Act, which Section 6 of the Criminal Code Act was declared null and void for the purpose of being supposedly inconsistent with the provisions of the Constitution. But Lordship, the evidence of this court that this contention does not apply to the instant case because the section to rape was clearly in existence at the time that my client was held to have or was said to have raped his wife. And this exception, the Lordship, was acted upon and in full force and was seen in the case in the suit number EN/CR/45/2019, where the High Court of the State in Enugu State, where the Enugu State High Court quashed the charge and discharged the accused based on the exception provision provided in Section 6 of the Criminal Code Act. Your Lordship, is on this ground that to apply this logic to this instant case, your Lord, is an affront and a direct attack to the principle and essence of the aforementioned sections. Your Lordship, assuming but not conceding that section.
Excuse me. In which case did you say the High Court of Enugu State?
No, it's suit number EN/CR/45/2019. Your Lordship, assuming but not conceding that section 6 of the Criminal Code Act is the declaration of section 6 of the Criminal Code Act being null and void does not act as assuming but not conceding that the declaration of section 6 of the Criminal Code Act as null and void does not act as a bar to the position of the accused. Your Lordship, I beg the indulgence of the Honourable Court that recourse should be made to the spirit of the law and to the space of the law. Your Lordship, I also want to draw the mind of the court to section 6 of 1 of the 1999 Constitution as amended, which is to the effect, which vests judicial powers of the court, which vests judicial powers of the Federation in the court of Nigeria. And Your Lordship, the main principle or the main purpose of the judiciary is to interpret the law. And this was given judicial blessings by your learned brother Atande Fatayi Williams in Awolowo and Shagari 1979 6-7 SC, where he noted that the function of the court to interpret laws. But I know the purpose of statutory interpretation is to decipher and decode the purpose and the intent of the law, and this was given judicial blessings by Lord Denny in Mago and Newport Corporation 1950 2-RER 1226 at 1236, where he stated that, and I quote, "We sit there to find out the intention of the parliament and ministers and to carry it out." He also held the leadership in Steeple Court Estate Limited and Asham, 1949, 2 KB 489, that judges should give effect to the purpose of the legislation of a law. Therefore, Your Lordship, before I continue, I want to reiterate the fact that justice must be given based on the letter of the law, based on the principle, based on the spirit of the law, and based on the face of the law. And we're talking about the face of the law, we're talking about the impact of the law, of the judgment of the court in the society, which unfortunately the Court of Appeal failed to take cognizance of. So, Your Lordship, if the decision of the Court of Appeal on this issue is applied strict sensu, this means that anyone who has been acquitted or who has been acquitted and discharged based on the principle of Section 6 of the Criminal Code Act will then be brought back and tried again, which is against the principle and essence of Section 36 of 8. And also against the doctrine of double jeopardy provided in Section 36 of 9, and against the principle of based on knowledge criminal sin level as provided for in Section 36 of 12. Thereby, Your Lordship, acting as thereby, Your Lordship, going against the fundamental essence of this constitutional provision. Furthermore, Your Lordship, this will further create a scenario where citizens who have relied on the principle of Section 6 of the Criminal Code Act are now tried again for an act which, at the time it was made, did not constitute a criminal offence, and which is against the principle of Section 30, provided Section 36 of 8, expressed by your learned brother, Sir Udo Udoma, JC as there was in Ipasa and Vendes, the full citation before the Honorable Court.
JC what?
No, Sir Udo Udoma, JC as there was in Ipasa and Vendes, the citation before the Honorable Court, where he held, and I quote, that in the first place, this was intended to prevent retrospective legislation, whereby an act which is innocent and which at the time was not criminal should overnight be converted into a criminal offence. He also held on this principle that this would prevent a scenario where a person where an act was made, where at the time being the punishment was lesser than that which was increased in a later case. Yes, Your Lordship.
You are still on issue 2.
Yes, sir. I'm rounding up, Your Lordship. Okay, Your Lordship. Therefore, Your Lordship, this defeats the principle of nullum criminal sine, which means no law, no crime, and which was provided for and given judicial blessings in the celebrated case of ANIEKWE and F.M.O, all Nigerian law reports 400. Your Lordship, I want to reiterate that as ministers in the temple of justice, it is our responsibility to ensure that justice is not only done, but it manifestly seen to be done. Therefore, Your Lordship, applying this principle to this exact case, it is in the interest of public policy and collective good that the criminals are not allowed or meant to be added retrospectively. And also considering the fact that this marital rape exception provided in Section 6 was renowned and well known, it will be a great injustice and unfairness on the part of this Honorable Supreme Court to hold the person liable of an act which he did not envisage or contemplate at the time the act was made. Therefore, Your Lordship, based on this principle, can that before the Honorable Court is a humble and firm submission that the decision of the Court of Appeal in this case be quashed, and that this Honorable Supreme Court dispose of the submission of the respondent into the legal dustbin of the temple of justice and resolve this issue in our favor. May this honorable court be pleased. I hereby pray the indulgence of the court to transfer the legal battle to my new counsel.
On issue 3, my lord, I'm referring the legal battle to my co-counsel, ANIEKWE, Esquire.
In my gracious lords of peace, I remain my own self, ANIEKWE, Esquire, and I will address this honorable court in the third issue, which is whether or not the Court of Appeal erred in law in finding that the doctrine of exculpation does not apply in public law and therefore inapplicable in the instant case, and also that it does not serve as a bar against the Attorney General arguing against the constitutionality of Section 6 of the Criminal Code Act and the prosecution of the accused. My noble lords, it is our contention and our submission that the Court of Appeal erred in law in finding that the doctrine of exculpation does not apply in public law and therefore inapplicable in the instant case, and also does not serve as a bar against the argument of the Attorney General against the constitutionality of Section 6 of the Criminal Code Act and the prosecution of the accused on the following standpoints. Firstly, that the principle of exculpation applies in public law, and secondly, from the applicability of the principle of exculpation in public law, it is therefore applicable in the instant case, and consequently, the Court of Appeal also have ruled and also prevented the Attorney General from arguing against the constitutionality of Section 6 of the Criminal Code Act and the prosecution of the accused. My lords, exculpation is clearly provided for and defined in Section 169 of our Evidence Act 2023, and nowhere was it mentioned that the principle of exculpation is exempted in any case, be it in public law or in private law. And it's a choice principle of our law that where the wording of the statute is devoid of ambiguity, and the literal meaning should be applied. This goes to say, my lords, that the principle of exculpation applies to all persons, and as a matter of fact, government bodies are regarded as persons, and this is exactly why they are empowered to sue constitutionally under Section 6 of the Constitution, Section 6 sub 6 paragraph B of the Constitution of the Federal Republic of Nigeria, 1999, as amended in the law. So the distinction between private law and public law with respect to the principle of exculpation, my lord, is a non-sequitur. My lords, as held in the celebrated case of Union of India and others against MS Indo-Afghan Agencies Limited, 1968, 2 SCR 355, that if democracy is to thrive in our society, then the different conduct of public bodies and private bodies cannot ordinarily be permitted. My lord, according to that case, that a public body cannot be exempted from the liability which arises out of the representation which such a public body made, and an individual has relied on it to alter his position to his prejudice, my lord. Assuming or not considering that exculpation does not apply to the state in its governmental capacity, however, my lord, there is an important exception to be noted, which is to the effect that the principle of exculpation can be applied against the state where it is necessary to prevent fraud and manifest injustice. And this is on the judicial authority of M. Ramananda Pillai against the state of Kerala and another, 1974, 1 SCR 515, my lord. The Court of Appeal views the principle of exculpation, which is an equitable remedy, as having nothing to contribute in public law. However, my lord, placing that on the plethora of cases I used before this honorable court, it is right and right to say that the view of the Court of Appeal was inaccurate, as exculpation can be applied in public law, be it in common law or in equity, and both varieties falls under the headings of exculpation in place, as held in the case of Dijon and Hart and Headsley, 1983, HCA, 11 to 156, CLR, my lord. Furthermore, my lord, on the principle of the high case, a party is legally barred from insisting upon the enforcement of his strict legal rights, where it will be unjust to enforce such rights, considering his previous dealing, my lord. And in the instant case, a
In a previous suit, charge number EN/CR/45/2019, the Attorney General has already made a representation that Section 6 of the Criminal Code Act was valid, and the Honorable Court of Appeal ruled based on the submission and argument of the Attorney General and punished the charge and thereby discharged the then accused, my lord. In the national case of United States and F.M.O 242 U.S. 85 1916, the Supreme Court of the United States held that a criminal charge that has been adjudicated upon by a court of competent jurisdiction may be pleaded as a bar against the prosecution of the same offence, my lord. Also, my lord, it is a matter of fact that naturally citizens are supposed to trust in their government, and they ought to do so, and they are not supposed to suffer for it. As held in the case of ANIEKWE Corporation and United States 291 U.S. 54 62 193, it is scarcely debatable that the actions of government ought to have more regard to justice and a higher level of morality than that which is expected of an individual, my lord. It is therefore our contention and submission, my lord, that having established the applicability of the principle of F.M.O in public law, it is right to say, and it also suffices to argue, that the Court of Appeal ought to have barred the Attorney General from arguing against the constitutionality of Section 6 of the Criminal Code Act, which he had in an earlier case held to be valid, and the court acted on it. And this is that case, my lord. The accused had acted on the same representation made by the Attorney General in the said suit, believing so to be the truth, since the office of the Attorney General is regarded to be the officer of the law, my lord. Every reasonable human would have done exactly the same thing, considering the fact that the office of the Attorney General is placed with being the officer of the law in the state, my lord. I will pray this honorable court to resolve these issues in favor of the applicant by setting aside the decision of the Court of Appeal. May this honorable court please. And I seek.
Let me ask one question.
Yes,
in paragraph 7.5 of your main brief, where you refer to the case of the suit number EN/CR/45/2019, you talked about knowledge prosecution. Was it?
Yes.
Was it in that case that the Attorney General entered the knowledge?
Yes, ma'am. Yes, sir. Yes, my lord. In the very place, the Attorney General entered the knowledge prosecution on the argument that Section 6 of the Criminal Code was valid. So the court acted on that representation of the Attorney General.
If knowledge prosecution, if it is entered, does not require argument. To terminate the case, puts an end to the case. How did it elicit the argument that led to going to the court?
Okay, madam, when the Attorney General entered the knowledge prosecution, his main reason of entering the knowledge prosecution was that Section 6 of the Criminal Code was valid. So it was no need charging the then accused. That was the main reason he entered the knowledge prosecution. That Section 6 of the Criminal Code was valid.
Possibly it was challenged that led it to the matter to.
Yes, madam.
Okay. Go on.
I pray this honorable court to hand over the power of audience to my lead counsel.
In summary, my lord, from the arguments now brought before this honorable court, it is statement, and in summary, from the arguments, it is logical to conclude that Section 6 of the Criminal Code is not in contravention with Sections 33, 34, 38, and 42. And also that Section 36, sub 8 and 12 does operate as a bar to the prosecution of the accused, both in the letters and spirits of the same sections, and that estoppel is a public law principle and should be used to stop the AG against argument against the validity of Section 6 of the Criminal Code. we pray this honorable court to quash the course of appeal judgments on the ground that on the first ground and on the first ground, the second ground, and the third ground, my lord.
And do what after that?
And grant their appellants and appease their appellants.
Okay, looking at the respondent
Your Lordships, the appellants have an objection to.
Are you appearing for them?
No, Your Lordship, I just wanted to take
If they fail to raise their preliminary objection, is it not in your interest?
Thank you, Your Lordship. Your Lordships, before this honorable court is a respondent brief dated and filed on the 18th day of January 2024.
My lord, a perusal of the respondent's brief of argument, we reviewed that the document was improperly signed. And according to the courts in MOOTING versus F.M.O in 2018, not particular electronic reports, the court specifically stated that where more than one legal practitioner are appearing in the suit, the legal practitioner who is making the signature shall be indicated. This indication can come in form of a tick or the word sign attached at the end of the legal practitioner's name.
Okay, you want to argue your preliminary objection now?
Yes, my lord.
Okay, respondents counsel, since you are eager to have him argue his objection, because it's you that reminded him of his objection, let us share the objection.
Okay, my lord. Please, having established that a document, for a document to be properly signed, the signature should be traceable to a particular legal practitioner, making the signature when more than one legal practitioner appearing. Then, on the effect of this, the document that is improperly signed, the courts in Sarai and another, as is Saguna and others, Law of Electronic Law Reports 2008 stated that a document that is improperly signed, to say the least, should be struck out, my lord. This was also regretted in the case of Bank of Industry Limited versus AO Zimbabwe Light Industries Limited 2018 Law of Electronic Law Reports, where the court struck out a document that was improperly signed and held that it does not follow the due process of law, my lord. And also in the Supreme Court's case of GCB PLC versus Innocent Nigeria Limited, the court struck out the Great Honorable Court, struck out the respondent's brief of arguments.
Okay, what will happen is that the respondent, you respond to the preliminary objection first, then you proceed to argue your brief. We shall now rule on the preliminary objection in the main judgment. What it means is that the judgment will first consider and determine the preliminary objection before we now go into the main substantive matter.
Your Lordship, I would be replying the objection as given by the appellant. Your Lordship, I would like to refer Your Lordships to the signature portion of the respondent's brief at the bolding end where it was stated for Group H. Your Lordships, may I proceed?
Did you understand the grounds for the objection?
Yes, that it was improperly signed. The Supreme Court, in the case of Network Securities Limited and Dahiro and others, citation 2022 LPELR/57835 SC, it held that the omission to state the particular legal practitioner in a firm that signed a court process cannot vitiate the court process. Furthermore, the court held there that once a court process is signed for an institution or a firm consisting of only lawyers and not lawyers acting in their personal capacity, that such a signature is competent. Your Lordship, at the beginning of this competition, we were assigned into groups, Group A to Group H. Now, the appellants have not brought anything to the fore before this court that any of the names which were written there or the signature which was signed there was not done by a member in Group H, which consists of only lawyers, student lawyers, which are present before this court. Therefore, Your Lordship, we pray this court to disregard the argument of the appellant on this issue. Your Lordship, before this honorable court is a respondent's brief dated and filed on the 18th day of January 2024. We wish to adopt this brief of argument as our argument in this suit. Your Lordship, we will be allocating our time as follows. My first co-counsel, I.M. will be canvassing our first issue for 12 minutes. My second co-counsel, N.O. Eze, will be canvassing our second issue for 9 minutes, while I, K.L. Ibuzo, will be canvassing our third issue for 9 minutes. Your Lordship, I therefore seek the leave of this court to call on my first co-counsel, I.M. Umore, to canvass our first issue.
With respect to Your Lordships, I remain my humble self, I.M. Umore, and I'll be conversing on the first issue of our respondent's briefs on whether the Court of Appeal in the majority decision erred in law in finding that Section 6 of the Criminal Code, vis-a-vis the exception it makes of spousal rape, offends Sections 33, 34, 38, and 42 of the 1999 Constitution in the light of the one and the same principle and public policy consideration in the opinion of the High Court, JCA. Your Lordships, it is a humble and firm submission of the respondents that the Court of Appeal in the majority decision did not err in law in finding that Your Lordships, Section 33 of the 1999 Constitution provides for the right to life. It provides that every person has a right to life, and no one shall be deprived intentionally of his life save in respect of a criminal offense of which he has been found guilty in Nigeria. Your Lordships, in consideration of acts which infringes on the right to life, the court in Chevron against F.M.O and others, citations before you, my lords, stated that acts which cause fear of harm or bodily injury to a person are such acts that infringes on the right to life of a person. The court also in Parité JSC in Williams and Williams Citation before you, my Lord, said thus: the court should consider the entire evidence before it, and although no specific instance of actual violence is given in evidence, it should be able, on objective appraisal of the evidence before it, to say whether or not the conduct of the respondent is of such a character as is likely to cause or produce reasonable apprehension of danger to life, limb, or health, whether bodily or mental, on the part of the petitioner. Your Lordships, violation to the right to life could take the form of threats to kill, intimidation, attempt to kill, conspiration, or even the actual killing itself. Thus, the right to life becomes enforceable once the right has been, is being, or is being contravened by another person. And this is codified by Section 46, Sub 1 of the 1999 Constitution, which provides that any person who alleges that any of this chapter has been or likely to be contravened in any state in relation to him may apply to a high court in that state for redress. Your Lordships, the act of rape infringes on the right to life because it affects the victim physically and mentally. Your Lordships, there is no scientific or judicial approval or authority to show that married women who suffers rape is not the same as unmarried women who suffers rape. So it therefore implies that if an unmarried woman can suffer from the act of rape, therefore a married woman can also suffer from the act of rape. Your Lordships, the appellant.
This one, a married woman can suffer, can be raped, but this one is by the husband.
Yes, sir, it is by the husband who is not supposed to rape her because they are married. He's supposed to seek her consent before having sex with her. So when it is from the definition of rape, when it is without consent and penetration takes place, that is what makes it rape. Your Lordships, the appellants in paragraph 5.2 of their appeal brief contains citing the case and decision in Chief Ede, Osayede, and Obon Okokon Edwin, Udo Etu, citations before you, my Lord, that both the man and his wife are indivisible because of the union of marriage. They however failed to take into consideration the explicit provision in Section 33 of the 1999 Constitution, which explicitly states that everyone has a right to life. The life of women will be infringed upon, and because of this, the courts in Ganiyu, Olatokun, and Oladiwon against the state stated that the husband of the victim was charged and convicted for killing his wife. If we are to rely solely on the fact that a man and a woman are one, and nothing is done about that without any restriction, it means that a man will rape or cause harm to the wife without having any cause to answer anyone. But by the provision of this case, by the decision in this case where the man was charged and convicted for killing his wife, it means that the man also is restricted despite the union in marriage.
Okay, did you capture the gamut of the crux of their arguments?
Yes, sir. Yes,
What
sir.
they said in their brief that when a husband is trying to have fun with the wife, he wouldn't be intending harm.
Okay.
Because the case you are referring to, you said the man was charged for killing his wife. Not as a result of rape, but applying some other force that could cause death.
Okay, my Lord. They reiterated on intention. My Lord, rape has some consequences which comes at times, be it who commits it. Now, trying to say that there is no intention to cause harm in rape, it is not trying to say that someone is going to steal another person's property but he does not have the intention to deprive that person of that property. I'm just trying to give this instance. So by the time somebody is raped, the intention to rape is already there. So whether he intends it to cause harm to the woman is not the issue, but whether the intention was already there to commit the rape, which is the crime in issue. On section 34 of the Constitution, my Lord, your Lordships, the right to the dignity of every human is explicitly provided for in section 34 of the Constitution, and section 34 forbids and prohibits inhuman, degrading treatment and torture. Torture was defined in the case of Uzo and Ezio citation before you, my Lord, as meaning to put a person through some form of pain which could be extreme, or to put a person to some form of anguish or excessive pain. My Lords, in paragraph 5.8 of the appellant's brief, it contains that non-consensual sexual activity between spouses in a valid marriage cannot amount to breach of the right to dignity of the woman, no matter the harm that may be resulted as a result of public policy rationale for the protection of marriage. However, my Lords, judicial authorities have affirmed that acts of cruelty in marriage can drastically affect the relationship between spouses. In the case of Ugoto and Ugoto citation before you, my Lord, the court held that a marriage could be said to have been broken down irretrievably if it can be established that one spouse had been guilty of cruelty towards the other, as no reasonable spouse will be expected to share a state of affairs with the other spouse who has been cruel to her. It therefore shows, my Lord, that for a man to rape his wife, there is no sanctity left in the marriage which should be protected or preserved. Yes, my Lord.
Just hold on, the court will rise for some minutes. We are coming back to continue the argument.
Yes, my Lord.
Court will rise.